Hello, this is Kathy Thompson, and this video is intended to introduce you to an appellate opinion or a case. Just that. It's not going to teach you how to brief it yet or even how to read it yet. I just want to show you what one looks like, introduce you to the different components of it. What I'm using to introduce you to an appellate opinion or a case is a free website called learnleo.com. You're welcome to look at it, try it out. I've got a couple briefs set up on there that if you wanted to brief them and share them with me, I'll take a look at them as soon as I can, give you a little feedback on them. But I will show you that in a different video. Today's video, I want it to be nice and short, and I want to show you the different components of a brief, of a case, an appellate opinion, because that's the starting point in being able to read cases for class and to understand what your professors are trying to get you to get out of the cases. And more importantly, what you need to get out of the cases so that you're not memorizing everything about the case. You're dividing the case up into its important parts, and you're taking out what you need to take from the case. And you're leaving on the page the things that aren't relevant to what you're learning at the moment. But first, let's talk about an appellate opinion and the different components of it. The way this portion of the website works, and let me just show you where I started. I started at the tutorial, and I went into law school lingo, and they give you a 4-minute tutorial on cases. And what you do is you click on each colored highlight. There's different portions of this case that are colored to learn about the important parts of a case. It's somewhat simplistic because what you'll be doing, as you'll see in later videos, you'll be asking yourself questions about a case, you'll be confused about parts of a case, and you'll be clarifying it either then or later in class or later. So it's not going to be, color code this, color code that. It's not as simple as that, but I do want you to see this. I think this is an important visual for you, and I think it can be very helpful. So I'm going to click on that. We're going to start here. Here's the name of the case. And at the trial level, the name on the left is the plaintiff, the name on the right is the defendant. Once a case is appealed from the trial level, the person appealing is called either the appellant or the petitioner, depending on the state that you're in. And the defendant is called the appellee or the respondent. For purposes of law school studying, what these people are called, and even for the most part their names, aren't things you need to worry about. Okay? What you want to pay attention to is what the key takeaways from the case is. And if you watch the prior video that talks about starting off right with the case studying method, the key takeaway is going to relate to some concept or idea in the table of contents. So it may relate to intent and intentional torts. It may relate to the actual cause of action of battery, and then it might relate to one aspect of that cause of action. So you want to always keep in mind, why am I reading this case? I don't have that information here, because this is a website that doesn't include that information, but you would have that information because you would be looking at the table of contents, reading the case with that in mind. Now, what I'm going to do here, just to show you, I clicked on this and the facts came up. So facts that are relevant to the court's decision are not always at the very beginning of the case. Sometimes what a court does is it gives you background facts and then it states more relevant facts later. But one element of a case are the facts of the case. So that's one element that you'll be looking for, one component. So here, paraphrasing it, during a game, plaintiff was suddenly attacked by an opposing player. After plaintiff struck back, spectators and opposing team members held plaintiff down while the first assailant bit off plaintiff's ear. Torts case. Okay. And you'll find some interesting fact patterns in some of your classes, and particularly in torts. So this is what happened. Notice that there's more facts in here. It's summarized here. You won't know which of these facts mattered the most until you read further the court's decision. So facts. Procedure. How did this case get before this court? Now, other than your civil procedure class, where procedure is going to be the heart and soul of what you talk about, you're going to note the procedure primarily for class discussion because your professor may ask you because they're trying to teach you procedure. But in terms of putting procedure as a general rule into your studying and memorizing it, you're not going to do that. Okay? So procedure, other than civil procedure. But in criminal law, torts, and contracts, as a general rule, while you may note this, and your professor might ask, how did this case get here? Because they're trying to teach you procedure, you won't be necessarily tested on that for that particular course. Okay, so basically it tells you the trial court denied the defendant's motion for summary judgment after the plaintiff sued Cosmopolitan for negligence, and that's something you haven't learned yet, and then defendants appealed. Okay, you'll learn about this concept of summary judgment in your civil procedure course, but I want you to get a Black's Law Dictionary. I recommend getting a paper copy, inexpensive on Amazon. Keep it right by you, look it up, okay? Because Black's Law Dictionary, in my opinion, is the most helpful dictionary out there. It will explain things in a way that will help you in your classes that right-clicking and going on to any basic dictionary won't. And I think if you're reading if you're reading in a case book and you're using the text to study, I don't think it's useful for you to go on your computer or go on your phone to look up a word. I think it makes more sense to pull out your Black's Law Dictionary. You can write in your Black's Law Dictionary, make notes to yourself. But things like that might be useful, particularly at the beginning of the semester. Look it up. Take a little longer. Don't spend an inordinate amount of time on a concept that you don't understand. But looking things up can be very useful. So there's a procedure. This is a statement of the rule or the principle of law used by the court to determine the outcome. So when I talked in the last video about what lawyers do, lawyers find the law, they read and learn the law by using, in this case, in this situation, a case, a judicial opinion that talked about the law. The law could also come from a statute that's been interpreted by the court. And as you're looking through, you want to look for general principles that are going to apply to these situations in general. So here, the student found, moreover, whereas here, an intentional or criminal act of a third person intervenes between the defendant's conduct and the plaintiff's injury, liability will turn upon whether this intervening act is a normal or foreseeable consequence of the situation created by the defendant's negligence. So that's a lot of words, but you're noting here, okay, this is the principle of law, and up here, I like this because it talks about the general concept, proximate cause, that we're studying. So I guarantee you that this case would have been listed under proximate cause in your casebook, and you're using it to understand this concept of proximate cause. You're not studying it now, you don't have to worry about it, but this is just an example of a rule. So if we click here, the court applied a rule developed in this prior case, Dr. Darian. This is a citation. You'll learn about that in legal practice. You don't have to worry about that now. For situations in which the defendant did not directly cause the plaintiff's injuries, but instead an intentional criminal act of a third party intervened. Much clearer, because the person took the time to figure out, what does this really mean? This is what it means. This might be something that the student also took from their professor after they talked about it in class and clarified it. See how this is much more simply stated. Courts will not always give you the most simple way to say something, as long as you say it that's accurate, make it your own. Okay. There's the rule statement. Now, the court's decision is a direct answer to what was at issue. And what was at issue was this. I skipped this, sorry. So the issue in the case is the key question addressed by the court. And the defendants moved for summary judgment, contending that their alleged negligence was not the proximate cause of the plaintiff's injuries. It's not as specific as some of your professors may want you to discuss it in class, but it's good enough for you to write down the basic question in the case. The question is whether the negligence was a proximate cause of the injuries. That has to do with what's required for a negligence cause of action, which you haven't learned and you don't need to worry about, but that's the issue. All right. You'll study in your torts course. Don't worry, you don't need to know about it now. In fact, your professor doesn't even want you thinking about it right now. All I'm doing is using this as an example of the different parts of a case brief, and then the reasoning. The reasoning describes the court's thinking, and this is a really important part of the case. What the reasoning is, it's the court saying, here's the rule. Here is this rule applied to these facts. Okay, and that is what you're going to be doing as a lawyer, and that's what you're going to be doing on your exams. So it's helpful to pay attention to how the court does it, because they can model this kind of thinking, because you're going to be spelling out your thinking for your professors on your exams. So the reasoning describes the court's thinking. It's the logic that led to the court's decision. So applying the rule to the facts of the case, the court reasoned that because the attack occurred without warning and because there was no bad blood between the two teams, the attack was not foreseeable. The court also emphasized that there were no previous issues between the teams and the acting referee, and that the presence of a trained referee would not have prevented the attack. As such, plaintiff's injury was not a foreseeable consequence of defendant's alleged negligence. So that's the court's thinking. And so just kind of spelling it out. So the court, you go back up here. Deposition testimony is simply testimony under oath. That's something you'll learn about eventually in your civil procedure class. Don't worry about it. There was no prior, don't worry about that language quite so much. There was no prior history of acrimony, disagreement, hatred between the plaintiff's team and the opposing team. The attack occurred suddenly, and therefore there was no reason to know that there would be this problem. Admitted that neither team had any problems prior, and there's no indication that. So therefore, it was foreseeable, so they couldn't have known, or they wouldn't have known. So there are the parts of an opinion, the facts that mattered to the court, which when I go through the process of case briefing, I'm basically going to have you lay those out towards the end in more detail, because what mattered to the court isn't always clear until you know what the rule is, what rule they're applying, and what their reasoning was. The procedure, how that case got there, the issue, the key question addressed by the court, and here it was stated indirectly. It's not always stated directly, and sometimes it is, so look for that language. The rule, the principle of law used by the court to determine the outcome. We knew that this case was under proximate cause in the table of contents, so we're looking for that language to help us define that term. And then the application of that term to the client's facts, and we've got the court's thinking. Notice in the reasoning, the court uses facts and law, right? and ties them together using because. Because this, there wasn't foreseeable, and it lends itself. It's modeling for you. Good thinking. I just wanted to see the different portions of a case brief. This is just for that purpose. The process of reading through a case and coming up with a nice, succinct explanation of why this case is in the casebook, what did I need to learn from it, will be in a different video.